Okay, hello everyone. Thank you all for being here. I'm going to talk to you about, I think, a really remarkable figure who was the main founder of our law school. I got interested in this because, as you will notice, my chair title has his name in it. And when I was offered this chair by Dean Baird, I wanted to wait and see whose name is going to be forever afterwards attached to my name. And so I did a bit of research and I liked what I found. So I was very happy in the end to have his name attached to my name. So when German Jewish immigrant Ernst Freund was asked by the University of Chicago's president, William Rainey Harper, to design a law school for the new university, he made a radical proposal. Freund was a lawyer and political scientist who used his broad knowledge of American society and its flaws in his own legal work and social activism. He told Harper that if lawyers studied only black letter law, as was then the custom put in place by Harvard, I should say, they would be incapable of being more than tools of the status quo. Instead, they ought to study law in a way infused by knowledge of political science, history, economics, sociology, and political philosophy, not in order to become academics, but in order to become lawyers who could think critically about society and guide it productively. The new law school, which opened its doors in 1902, followed Freund's ideas, inaugurating a new era in legal education. Today, the interdisciplinary curriculum is dominant in every major US law school, but this broad conception of legal education has recently come under attack. Numerous experts have sought to return law to its narrow and, I think, relatively subservient origins. The buzzword is cost, but of course, powerful social forces seek lawyers who are pliant and not boldly independent of convention. In this talk, I'm going to describe Freund's vision and the arguments with which he defended it, and then describe the current Freund style curriculum. But then I'll look at that debate. Okay, so Freund, one of the greatest legal minds in US history, is seldom discussed today. And yet, in his lifetime and for several decades after his death, he was acknowledged as a giant. At his memorial service in 1932, Jane Addams, whom you may know as the legendary social activist for the poor, spoke of Freund's role in, quote, projects of fundamental social research, which would in the end develop cooperation between legal scholars and those most cognizant of life where it presses hardest and most unfairly upon those at the bottom. And she concluded, he was probably the finest exponent in all Chicago of the conviction that as our sense of justice widens, it must be applied to new areas of human relationship or it will become stifled and corrupt. A man possessing this passion for justice, this appetite for its new applications, is a great asset to any community. But when this passion is combined, as in the case of Professor Freund, with a scholar's legal knowledge and with a mind sensitive to social growth and change, we may indeed be grateful and consider his ideas, consider his loss irreparable. Leah Wormer, a leading Chicago lawyer, spoke of Freund's role as an activist philosopher, saying, a philosopher may peer into other worlds, but must not fail to honor his own. And he went on to describe as Freund's central conviction the idea, quote, that if the government is not to be mastered by ignorance, it must be served by intelligence. Felix Frankfurter knew Freund well and viewed him as a mentor and a pioneer in the study of administrative law, which, of course, was Frankfurter's own field. On a visit to Chicago in 1954 to inaugurate a lecture series in Freund's honor, I think that no longer exists, but it's kind of morphed into the chair. Frankfurter spoke of the pious gratitude with which he viewed Freund's life and work. So, who was Freund? Ernst Freund was born in New York City on January 30th, 1864, while his German parents were tourists in the United States. So he became, by accident, a US citizen from birth. But he grew up in Dresden, in Germany, in what his biographer describes as a middle-class Jewish environment. I corresponded actually with Freund's daughter shortly before her death, right after I got the chair, because I wanted to find out whether he was a practicing Jew and what his attitude to that was. She told me in later life, he was not an observant Jew, but he always spoke proudly of his Jewish identity. He attended gymnasium in Frankfurt and then the universities of Berlin and Heidelberg. He received a law degree from the latter. But he soon decided to take advantage of his US citizenship to pursue his education further in the US. He practiced law in New York for 8 years, but during that time, he was also teaching as an adjunct at Columbia and doing a political science PhD there. And in fact, he always spoke with a German accent, people tell me. In 1894, he accepted an offer to join the faculty at the new University of Chicago, which opened in 1892. Of course, they didn't have a law school then, so he was a professor of political science. And so it was as a really quite young scholar, only age 38, and as a Jew at a time when there were extremely few tenured Jews anywhere in the US Academy, that Freund became the chief architect of our law school, which opened in 1902. Freund's academic achievements include 20 books and several hundred articles, but numbers don't do justice to the magnitude of his contribution. Above all, he's known as the primary founder of administrative law. At a time when administrative agencies were just beginning to play an important role in government, he saw that a lot needed to be said about their scope, their powers, their limits, and particularly important, their relationship to individual liberty.
Oh, aren't you great?
Somebody, please mute yourself if you're not me. This topic had never been taught in law schools, nor had legislation, which was Freund's other primary part of the teaching curriculum. But his interests were as broad, actually, as the problems of the nation. So let me just give you some of his primary contributions. First, immigration. At a time, and it's not the only time, obviously, when immigrants were flooding into the US, but were also meeting with great suspicion and hostility, nothing new there. Freund saw that law needed to step in to prevent mass deportations without due process, which had been influentially proposed. He wrote copiously on this question, both academically and in the press. And when injustice was done, as in the infamous frame-up of immigrants Sacco and Vanzetti, he raised his voice loudly, despite the fact that as an immigrant in a very anti-Semitic nation, and an even more anti-Semitic legal profession, where, by the way, Jews were not welcomed in white shoe firms until well into the 1970s, he was not out of danger himself. He opposed all systematic restriction of immigration, and he was particularly vehement in opposition to mass deportation legislation, which had been proposed in 1926, with Julius Rosenwald, the legendary anti-racist philanthropist and civil rights activist, and with fellow law academic and federal judge Julian Mack, founder of the American Jewish Committee. Freund co-founded the Immigrants Protective League. Second topic, police power, another contemporary issue for sure. One of Freund's most famous contributions is his massive book of that name. It's actually sitting in my office at the present moment, but if you recall it, you can read it. Published in 1904, 819 pages of very small print, an exhaustive analysis of the proper use of governmental coercion and the proper role of individual liberty. Third, free speech and dissent. One of Freund's most famous achievements, at least in hindsight, was his argument that our First Amendment covers the free speech rights of dissidents during wartime. He wrote apropos of the conviction and imprisonment of socialist Eugene Debs, who had tried to get people to resist the draft in the First World War, at a time when leading members of the judiciary, including the great Justice Holmes, had denied that the First Amendment could be so interpreted. The First Amendment, as Jeff Stone's wonderful book will tell you, began with very humble and narrow origins. So Freund's argument, which was published actually in the New Republic, which in those days used to be a liberal journal, it persuaded Learned Hand and soon it persuaded other leading figures. By now, Freund's view is commonplace and is viewed as part of the very core of what the First Amendment protects. Next topic, race. There was no prospect in those days of totally doing away with Jim Crow laws, but Freund always energetically kept pressing the issue of racial injustice. He was a prophet in the wilderness. In The Police Power, he wrote, quote, "It is extremely difficult to reconcile race distinctions with the principles of our constitutional law." And in 1916, he wrote, "Race remains a sinister distinction which the law has not fully overcome." Legislation. This area of public law, like administrative law, had not really been studied by the legal academy, and Freund took the lead here again. One salient aspect of his work there was the argument that legislators should protect personal liberties against government intrusion, spelling out clearly what incursions were permissible and what were not. Well, there are a lot of others I'm not going to have time to talk about, but I'll just name them: international law and world peace, criminal law and criminology, local government, family law, and labor law. But I will say something about law and economics. Freund was not an economist, but he understood that the Industrial Revolution had created new challenges for law, and that economists were badly needed to help lawyers make progress. The new role of corporations, the ascendancy of the railroad barons, the new need for commercial law and bankruptcy law, all these topics, which just weren't taught in those days in other law schools, were at the center of where law needed to go, according to Freund. Even standard subjects like torts and contracts, he thought, would have to move with the times and have more economics in them. And I mentioned this area last, despite its prominence in the curriculum Freund designed, because it wasn't an area in which he himself did creative work. But his keen eye foresaw its rise. And interestingly, and I think it's important to take note of this, its importance for the critical and justice-oriented function of law that he made central. Now, I've spent time on these achievements, above all, to give you a sense of Freund's political context, his ideas about the roles for law in a time of rapid social change, and the large social problems that motivated his ideas about the law school curriculum. We're living in quite similar times in many ways, so the parallel between Freund's struggles and our own gives us reason to attend to his curricular ideas. So now Freund and the Chicago Law School curriculum. So the University of Chicago, as I mentioned, opened its doors in 1892, admitting from the very start both men and women, and notably in roughly equal numbers. African Americans were also present from the start. So the university that Ernst Freund joined, as one of the very rare Jews to be appointed to any tenured position, was already conspicuous for its inclusiveness, which was radical for its time. It was in this context that President William Rainey Harper entrusted the design of the new law school to this young political scientist with a foreign education. Now, needless to say, at the law school already, before we got to the curricular design, women and African Americans were admitted from the start. I note that Harvard Law School did have African Americans quite early, 1869, before our university existed, but women were not admitted to Harvard Law School until 1953. Okay, Harper initially thought not of a law school, but rather of a research department of jurisprudence. He feared that a genuine professional school would be too intellectually thin to contribute to ongoing debates about the goals of our society and the nature of social justice. And indeed, as practiced at that time at Harvard Law School and elsewhere, legal education was both thin and narrow. It had little to say about broader social questions. The dominant method of study was the famous case method, pioneered by Harvard's great architect Christopher Columbus Langdell, who lived from 1826 to 1906, and he was law school dean from 1870 to 1895. And this was a method in which the cases were considered as Baconian data from which eventually principles would be inferred, and eventually they would work up to first principles, and then a deductive science of law from first principles back down to the new cases would be constructed. So that was the idea. Of course, the case method as it was practiced never quite got that far. But anyway, that method deliberately ignored historical and social context. Langdell felt that it had to do that if law was going to be respected as a science, not as merely an empirical apprenticeship. Unacquainted with the budding social science disciplines, he clung to the natural sciences as his primary model. Contacted by Harper about the future of law in the university, Freund argued that the University of Chicago should not content itself with creating a research department of jurisprudence. Instead, it should think of a new and richer way of training lawyers for the profession. Our country, he argued, needs lawyers who can think broadly about social issues, and what they need from their education includes both excellent technical legal instruction, he never denied that, and the input of social science and political philosophy. He emphasized the great importance of public law, which at that time wasn't actually taught in major law schools. They were entirely devoted to private law. The study of public law, he insisted, was not just for researchers, but for practitioners themselves, so that they could serve the public good with a widely informed and critical perspective. Looking back at his creation in 1932, he summarized what he told Harper. Unless a university law school explores all the resources of law, learns from history, and inspires itself by universal ideals, it does not do its full duty to the legal profession. But if, inspired by these ideals, it succeeds in broadening and deepening the law consciousness of the legal profession, and indirectly thereby of the community, that will be the most valuable contribution that a university can make to law and to legal science. He also told Harper that if the new professional school had the highest standards, an emphasis on research would naturally develop. And I think we can see the wisdom of that prediction. Harper quickly agreed with Freund, and the result was that the first curricular proposal for the new law school, drafted by Freund, included a great deal of constitutional law and administrative law, along with criminology, experimental psychology, comparative politics, and the history of philosophical ethics. Interestingly, both constitutional and international law were required in the first year, although later, as you'll see, they get moved to the second and third years as a result of the conflict that I'll describe. Freund himself continued to teach both in the political science department and in the law school. His courses on constitutional law, administrative law, and legislation, notably something that we've recently gone further in the direction of giving prominence in the curriculum, were pillars of the new curriculum. Concerning legislation, this comment was made in 2003 by one of Chicago's most eminent legislators, Len Dupre, 1908 to 2009. Notice he died at the age of 101, and I actually met him, and we all who were around then knew Len Dupre, a great liberal alderman who represented Hyde Park for many years, who desegregated housing in Hyde Park and in the laboratory schools, and was in general a major force in racial integration in the whole city. And so this is what Len Dupre said about Freund. Of all the members of the faculty 75 years ago, the memory that long, Ernst Freund made the deepest impression on me. He gave a course on statutes to a small, highly select group of students. In his teaching, Ernst Freund was always in touch with a reality that often escaped us elsewhere. In our first class session, he announced that the textbook for the course, the current Daily News Almanac, that cost 50 cents. It contained the recent statute on radio broadcasting, which we studied all quarter, And so that's the way he taught. And then Dupre goes on, gracious toward students, debonair, learned, and witty, Ernst Freund taught through conversation with us. There were hiccups along the way. As his first dean, Harper, I don't know quite why, hired Joseph Henry Beale, a scholar trained at Harvard, and who continued to teach at Harvard while he was doing his deaning in Chicago, simply visiting Chicago for half of the school's first 2 years. Harper was very keen to have the imprimatur of Harvard on his new law school. Freund thought very highly of Beale, and Beale actually was an important scholar of criminal law. Some of his articles are still assigned today. And so Freund thought highly of him as a scholar and suggested that he be appointed to the permanent faculty. But it was Harper's idea that Beale would be just loaned to Chicago as dean to help set up the school. A conflict soon emerged. The Harvard Corporation voted Beale a 2-year leave to set up Chicago only, quote, provided that the school to be established at Chicago is to have ideals and methods similar to those of the Harvard Law School, end quote. When Beale arrived and he understood what Freund was trying to do, he really didn't like it. He insisted that if he were to accept the offer, he would have to insist on strict replication of the Harvard-Langdale curriculum. In particular, every single faculty member hired would have to agree to teach by the case method, and no non-lawyers would be allowed to teach. Freund actually was a lawyer as well as a political scientist, albeit with a German law degree. He never got an American law degree. But another faculty member that he had already recruited, Henry Pratt Judson, a legal historian and future president of the University of Chicago, was not a lawyer at all. Beale didn't like Freund or his idea of linking law to the humanities and the social sciences, and he viewed these ideas as heretical and foreign, apparently alluding particularly with dislike to Freund's sympathy with German methods of education. It's also certainly possible that his animosity to Freund, which persisted long after they arrived at a curricular compromise, had something to do with anti-Semitism, which was then the norm everywhere, pretty much in the legal profession. In the end, the conflict evaporated amazingly quickly. Beale told Freund that actually the conditions imposed on him by the Harvard Corporation were more Harvard's ideas than his own, and Freund apparently agreed amicably to a compromise. And the compromise was to transfer administrative law, constitutional law, and international law to the second and third years. And nobody seems to have paid any attention to the Harvard Corporation's requirement that all faculty teach by the case method, nor did Beale ever try to stop the non-lawyers, such as Judson, from teaching. The two men agreed in demanding the highest intellectual standards in the new law school, and that coincided, of course, with what Harper wanted from the beginning. At the end of the day, when the new school opened in 1902, its curriculum was basically the plan that Freund had designed, and just a little bit changing from the first year to the second year. Let's now fast forward to present times. Freund's notion of how to run a law school is the dominant one in all major US law schools today. And I should also say that although it's more difficult in other countries where law is a first degree and not a second degree following a liberal arts education, it's also catching on in other countries. Korea adopted it some time ago. And what I actually wrote this paper from which this talk is derived for some people in Australia who are trying to move Australian legal education more in the direction of Freund's ideas. And that is happening with great success. So Freund's ideas in the US spread gradually, and they attracted imitators around the country. His model explains why philosophers, psychologists, economists, political scientists, and other scholars from other fields now teach in law schools, and why many law schools encourage law students to take courses outside the law school, although ours does it much more successfully than virtually any other, because luckily the law school and the rest of the university are on the same campus and basically the same calendar. Unfortunately, it's very short-sighted, but that just isn't true elsewhere. Yale has a very different calendar for the two. Harvard has a somewhat different calendar, but still making cross registration very hard. Georgetown has a lot of good rapport, but two completely separate campuses, quite far apart from one another, and so on. Even Cornell, where the calendar and the campus is the same, Cornell still imposes bureaucratic opposition to cross registration through a kind of bureaucracy. So, in any case, all major law schools have adopted something like the Freund curriculum, and all have, as Freund's original law school had, a few faculty who don't even have a US law degree. So, for example, me and Dhammika Dharmapala, who has an economics PhD and not a law degree, and an increasing proportion of the faculties of all of these law schools do have advanced training in another subject. I'm not going to do a count of our faculty here, but basically, out of the 40 or so faculty we have, approximately half have a PhD in some other discipline. Those disciplines include philosophy, political science, history, anthropology, and I think that's, and of course, economics is the most numerous one, and that adds up to quite a number of people. Some of those are cross-listed in those other departments, others are only in the law school, but in any case, we have a very interdisciplinary faculty with a lot of PhDs, and that doesn't even really do justice to the faculty's pursuits, because the faculty who don't have a PhD usually do advanced scholarship in some interdisciplinary way. So the PhD, I think, is not de rigueur if you're doing law and economics work. You just have to do the work. If you want to do legal history in a law school or legal philosophy, a PhD is pretty much de rigueur. But most people can work in a way informed by these disciplines without a PhD. This ethos, of course, is fostered greatly by the liberal arts system of undergraduate education. Law in the US has never been a first degree. It's always required BS or a BA before you come to law school. And so what this means is we can rely on the fact that our students are reasonably mature intellectually. They're older in calendar age than European law students, and most have studied at least some history, philosophy, and political science, because again, our undergraduate system is more interdisciplinary than most of the European systems where you enter university to study just one thing. A large number have studied some economics too. Now, this system doesn't mean that there's any one thing that all our law students know in common, but it does mean that in any class, there's a lot of trained and more or less sophisticated expertise that one can elicit. And increasingly, too, in gender studies. So since I began teaching feminist philosophy, where the law students who took it usually had not been exposed to any of the readings that I recommended, now we have people who have really majored in gender studies in the law school. So a more advanced course offered in one interdisciplinary field will surely have a constituency. Every year I teach a graduate seminar that's sort of mainly aimed at philosophy PhD students, but I always have, and I'm very delighted to have, three to six or so law students in that class, and some of them really, I mean, they mix very well with the other students, but some of them actually are the outstanding participants in those classes. And they're not always necessarily people who had majored in philosophy as undergraduates. So it's a very good mixture. In my seminar this fall, which was on tragedy and philosophy, I actually had about 7 graduate students in philosophy. Then I had about 3 graduate students in political science. We had 2 graduate students in social thought, 3 law students, and people from Northwestern who audited it, 1 graduate student from the English department. It was fantastic, and they all blended really, really well together. And that's really the ethos of the University of Chicago. The role of philosophy in our law school from the very beginning has not been limited to analytic jurisprudence, though I think that's very important, and we were very happy to appoint Brian Leiter to take charge of that part of the curriculum. Freund already favored a broader role for philosophy. He favored the study also of normative theories of political ethics and social justice. Okay, so how did this idea come to be under assault? What's in the air, or what at least has been, I think it's fortunately fading out a bit now, is the idea that we can't afford the old 3-year law curriculum with its invitations to elective courses and hence to interdisciplinarity. We must gradually replace it with a stripped down curriculum aimed more narrowly at legal practice. So it's kind of back to the beginning. Some proposed a 2-year JD. Some keep the 3rd year, but they want to devote the 3rd year to externships and the beginnings of legal practice. Given the number of courses that a legal education must include to fulfill Bar Association requirements, if you drop the 3rd year, you really don't have much time for interdisciplinary electives. But the recent insurgency says, oh, that's not any loss. In an op-ed in the New York Times, Daniel Rodriguez, then Dean of Northwestern's Pritzker School of Law, and Samuel S. Stryker, professor of law at NYU, called the 3rd year, quote, the 3rd year, those famous semesters in which, as the saying goes, law schools bore you to death. They don't offer a source for this supposedly famous saying, so they kind of conjure their own support out of thin air, I think. Proponents of the stripped-down curriculum, quoted in an earlier article in the New York Times, singled out a course called Nietzsche and the Law as a particularly boring and useless exercise, apparently without having read any Nietzsche, whose ideas of ressentiment and the creation of alternative values by the dispossessed are extremely germane to our present political moment. In fact, neither I nor my colleague Brian Leiter, who is an expert on Nietzsche, knows of any such course in any law school. So probably it was made up to be an example of something that would immediately strike people as useless. How short-sighted that very example shows the stripping down to be. The attack began to gather steam. The New York Times kept running stories taking the side of the 2-year JD. And when practicing lawyer Chuck Wolf, who also teaches employment law in our law school, when he and I co-authored an op-ed defending the interdisciplinary curriculum, and I should say we did that because somebody without a law degree writing on one's own would not have much credibility, but also because Chuck is the brother of one of the most eminent philosophers in the United States, Susan Wolf. And so he was interested in this idea from the beginning. So anyhow, we submitted this op-ed of ours, and the Times frankly acknowledged to us after sitting on the op-ed for a couple of weeks that they weren't interested in running arguments on the other side. Even President Obama spoke out in favor of the 2-year JD. Obama's intervention was hailed by S. Stryker, who said, romanticizing the fight into a heroic crusade, quote, we academics toil in the wilderness. It is great to have the president join the cause. Numerous institutions began offering what they called 3+3, a system under which you could get a BA and a law degree in total of 6 rather than 7 years. A smaller number of institutions, including Northwestern, introduced a 2-year track, and many students considered that track. Well, I'll tell you what happened to that later. And many law schools considered going over to that system entirely. Legal pundit David Latt, who then was in charge of Above the Law, sided with the attackers. And a Bar Association task force recommended 2 years of classwork plus a 3rd year of what they called skill-based experience. The leading factor cited was cost. The idea was, and of course it's not a stupid idea, was that undergraduates today graduate with much more debt than in the past. Meanwhile, law jobs are less certain than they were formerly on account of the economic downturn that began in 2008. The risk of double debt was, and I think still is, a real problem. Part of this is not the fault of law schools. The costs of undergraduate tuition, even at public universities, have risen rapidly, and financial aid has not always kept pace. But part of the problem seems to me a lack of foresight on the part of the law schools themselves. Undergraduate institutions, both public and private, have been offering massive scholarship aid for decades. High quality institutions typically try to attain what is called need blind admissions, meaning that all admitted students are supported by financial aid up to the level of need. Law schools didn't do that at all originally, and only have more recently begun to raise funds for that purpose. Students usually have taken out loans, and the first kind of financial aid was loan forgiveness for public interest law. And so the schools did start to offer public loan forgiveness for students choosing a career in public service, but only more recently have they offered outright scholarships. And it's still not that widespread because funds had not been raised with that idea in mind. Now, all of that is changing, and it's changing quite rapidly. And I think it's great that some major donors have jumped into this and have supported legal education in this way. But it will take time to make up the lag fully so that everyone gets what they need. So the issue of cost is huge, and I don't mean to brush it aside, but means should follow ends. And we must first get clear about whether and why our traditional method of legal education, it is by now the traditional method, is valuable, as the experts from NYU and Northwestern say it is not. I think we should answer today's attackers in just the way that Freund and Harper answered their critics from Harvard. Our societies are not perfect, to put it mildly, nor are its laws perfect. Lawyers should not just know the cases and thereby get absorbed into the system and become instruments of the status quo, obeying its norms without reflection. That's basically what I think a two-year curriculum all too often produces. They should be independent and critical participants who work to shape a future that's better than the past. Far more than many nations, you should take pride in this, I think, US has in fact realized broad social objectives through lawyering. Both the civil rights movement and the feminist movement offer stirring examples of how practicing lawyers who think outside the box can do something major that benefits us all, from Thurgood Marshall to all the feminist lawyers who created the reform in rape law and created a new sexual harassment law out of their legal education. When I work with the women's movement in other countries, it's striking that there isn't always the same confidence in the legal profession, because the legal profession has just not merited that confidence, particularly in India, where I've worked quite a lot, and where law is a kind of not very respected profession, and it does devote itself entirely to doing private law, almost no public law, and most of the people who are there are intended to go into the corporate sector. In India, feminists just don't think that you would turn to law for social progress. And again, on caste and other religious discrimination issues, they don't turn to law either. Law is often more part of the problem than part of the solution, as in one really awful case where students at the Jamia Millia Islamia University, which is a large proportion of Muslim students, were arrested on false pretexts by the police. And then the Bar Association in that region took a vote that they would not offer those Muslim students legal representation. Now, I think in the US, the bar associations are not perfect, but I can't imagine a major bar association taking a vote, we won't offer legal representation to women or to African Americans or other minorities seeking justice. So we've done something good, and we've done it, I think, in significant part, because of interdisciplinarity, and I would say the inclusion of normative political philosophy within that interdisciplinarity. But nothing is ever really done. It's all vulnerable work in progress. easily set back. So I think we need to fight to preserve the interdisciplinary legal education that the University of Chicago basically created, and fight to keep it in a form that's not watered down, a form in which the philosophical study of justice, equality, liberty, race, gender, and much more will play a central role. So it was in 2013 that Chuck Wolf and I, finally published on Bloomberg View our defense of the Freund curriculum against its assailants. But since then, I'm very glad to say the 2-year JD has started to slink away. It survives only at a few schools that are not the major law schools. Interestingly, the late Justice Scalia joined our side in a commencement address he gave at William and Mary Law School in 2014. Discussing the recent Bar Association report, he said, as he so often said on the court, "I vigorously dissent." And then he said, and I quote him, "It seems to me that the law school in 2 years proposal rests on the premise that law school is or ought to be a trade school. It is not that. It is a school preparing men and women not for a trade, but for a profession, the profession of law." Although Justice Scalia did, in fact, get his law degree from Harvard, his deeper affiliation was always with the University of Chicago, where he taught for 5 years. By now, even the New York Times acknowledges that the 2-year law degree has failed to catch on. Northwestern canceled its 2-year track in 2015. Dean Rodriguez, speaking of the defunct program as the holy grail and as, quote, like field of dreams, amazing images to use for like cheapened law education, admits that that track has failed to attract enough applicants. Oh, why might that be? The Times story blames costs. It's an interesting irony, given that the whole idea of the 2-year degree was supposed to be motivated by costs and to be lessening of costs. Rodriguez alludes obscurely to economic and regulatory forces, and then says falsely that the program, which opened in 2010 and was heavily hyped in 2013, predated the economic downturn, which of course began in 2008. The Times story does not mention the economic recovery, nor, more important, does it point to the fact that mature young people are capable of thinking for themselves and evaluating the richness or the poverty of the education that is on offer. And so, too, are law firms seeking to hire well-educated lawyers. We still have to keep fighting in an era of new economic constraint, and also an era when the humanities and social sciences themselves are increasingly under attack, and the very idea of a liberal education is in jeopardy, as I think it always is. My first question of our newly appointed president was, is he going to defend liberal arts education? Very glad to hear first from Jonathan Lear, who was on the selection committee, and then from the new president himself, that he's a great fan of liberal education. So, but it's always a fight, and we can keep the fight going by pointing with pride to the work of our graduates as engaged participants in our diverse and troubled society. And I'm glad to see that both on race and on gender, Dean Todd has sought to do that, always highlighting these graduates who have served our world so well through their contributions. So in short, law is not simply a trade. Law school is not simply a trade school. It is a noble profession that has a large role and inevitably will continue to play a large role in guiding society. And I believe, and I'd like to hear your views, and that's why I'm going to end a tiny bit early to have more questions. A broad interdisciplinary education of the sort that Ernst Freund wanted is crucial if lawyers are to play their role with independence, with critical reflection, and a rich, educated sense of what justice demands. So thank you, and please don't use the chat because it's confusing to look in two places at once, but use your yellow hand and raise your hand to ask questions. And now we have quite a lot of time for questions. Okay, Alex Green, please unmute yourself.
Hi, Professor. Thank you for the talk. Um, I'm a 1L, and I have noticed the curriculum for people who are interested in financial markets and law in that area, that there are a lot of classes for those fields.
Right.
And I'm wondering if you have any thoughts on whether someone's professional ambition for working in that area restricts opportunities for them to be exposed to more interdisciplinary type classes, reflective classes, and if that might have any impact on the norms of the legal relationship with that industry. Thanks.
Well, thanks. It shouldn't, because I think you need that just as much as anyone else. These financial industries are not short of ethical issues to be discussed, to put it mildly. I haven't really studied the numbers of courses that you would have to do to get expert training in that, and whether how much extra time that allows you. But let's point out that I teach a 1L elective, for example, every single year. So there's philosophy in the 1L elective. There's philosophy in the law philosophy workshop, which you can take in the second and third years. And there are quite a few courses that count fully as law courses. So you don't have to go across the midway and burn an elective to get a philosophical course that has justice content. But it's also the case that, many standard law courses, and it varies with the instructor, obviously, but we have lots of people who are interested in these normative issues of political justice. So any course you would be likely to take in gender or race or things related to that and criminal law certainly would involve a very strong normative component. You can't even take first year crim law without being exposed to theories of punishment, which have a strong, of course, normative arguments at their back, and engaging in those debates. So I think, I would like to see as much as possible these philosophical perspectives introduced in the first year. And of course, Elements was the course that standardly did that, and we've gone through very many different moments of Elements and what it contains and so forth. But that was typically where law students made their first contact with normative perspectives, often involving feminism and critical race theory as part of what was learned. So we have to keep our eye on that and keep reevaluating that course and the rest of the first year to make sure it does offer at least a taste of those normative perspectives. And then, of course, once you have a taste, you can go on and elect. And I would like to see more students who really don't intend to, let's say, be public defenders or engage in public law in general, take my elective courses. One of them is feminist philosophy next year. One of them, I alternate with that emotions, reason, and law, which, again, just because of what I am able to know enough about, it focuses on examples from criminal law and con law. Okay, but there are plenty of issues, normative issues in private law, and we probably, that is the weak point of our current curriculum, I think, because Brian teaches the standard jurisprudence courses. What I teach focuses on public law and crim and feminism, but also con law more generally, sexual orientation law, and so on. So torts and contracts, I think it's important for people to realize that there are these normative issues in those fields too, and we need to, encourage people to explore those and go outside the law school to take philosophical courses to get acquainted with that dimension. But I would say our law and economics faculty is normatively very tuned in. Economics, in a lot of the rest of the profession, has basically become so heavily mathematized that no one is talking about the normative arguments, because it seems like anything that's basically philosophical is like baby talk to people who do advanced mathematics. But that's not true of people who do law and economics. I teach global inequality with David Weisbach. He's very interested in the normative issues. So the class is sort of half economics and half philosophy, but it's not divided in that way. We go back and forth. And I've written extensively with Saul Levmore, a book on aging, which of course is all about normative issues. So I think our law and economics faculty are special, and maybe law and economics is itself special within economics, being very world oriented and therefore, of course, normatively oriented. So if you just explore the curriculum, I think you'll find a lot that you can take advantage of.
Thank you.
Hi, Professor Nussbaum.
Hi.
Can you hear me?
Yes, now I can hear you.
Okay. Um, Sorry, I'm using the phone. But
Oh, I see.
okay, thank you so much for this talk. It taught me a lot about kind of what Chicago law is, and in particular, it kind of focused my attention on how interdisciplinarity can make a difference to lawyering, and to legal education. I wondered if Freund or if you have a view about how law, either kind of black letter law or the legal profession, can contribute in the other direction. What kinds of effects can legal scholars or lawyers have on normative political philosophy, or on economics, or on the social sciences? Is it a two-way street?
Yeah, that's a really great question. When I first sought out law school teaching, so I was at Brown University, which has never had a law school. So I took a visit here thinking that I might want to join, at least in part, a law school faculty. My reasoning was the other way. It was about how I might influence people who will go on to clerk for Supreme Court justices, and how I could funnel these ideas into the larger public sector. And I said to myself, well, there are two public areas that I'm very interested in: the way things are done here in the United States, and the whole global justice context, where I had been working already with Amartya Sen and other economists on global development issues. And the thing about the global context is that every country is so different. And so to influence the way things are done globally, I mean, you really can hardly do it. You just have to teach students who are going to go to each country, and then they're going to do it, because I can't. I was once asked to talk to the Indian Supreme Court and tell them what to do, but you just don't, you should not do that. You should not be paternalistic and just apply your normative ideas. You can put them out there. And I think a lot of people have taken up my capabilities approach and used it in their own way. But I thought that the most direct and reliable conduit for a public influence by me would be the law school route. Now, as time has gone on, I think that's not. I think global has been very fruitful, and now that we have an international association, the Human Development and Capability Association, bringing people together for the purpose of mainstreaming the capabilities approach, things are better on that front. But I guess what I discovered in the meantime was that your other direction is really right. I came to love learning about law, learning about what we can learn as philosophers by knowing a lot of law. I actually audited Steve Schulhofer's crim law class. I taught a seminar on sexual autonomy and law with Steve while he was here. He was one of the great pioneers of feminist reform in crim law. So that was important to me as a feminist. I learned how we can do things in law. And then I also audited a number of con law classes, Mike McConnell's Religion and the First Amendment. And I actually have taught, the one black letter law course I have taught is Religion and the First Amendment. I haven't done it recently because there are other people who want to do it, who are more keen to do it and I have too many other demands. But anyway, that taught me a lot. And particularly, there's a new book I have coming out in May, which is about sexual assault. It's called Citadels of Pride, Sexual Assault, Accountability, and Reconciliation. That book, you would see, shows how much I've learned about law and from law. Because one whole third of the book is about how women have made progress through law, but about why law is actually important for feminists. What is embodied in the ideal of the rule of law? I think it's actually quite important to think about that for feminists at this time. Because, for in many respects, the Me Too movement has thrown us into what I would call a shame punishment culture. Having already written against the idea of punishment by public shaming, I have noticed that's actually what we got in a lot of the Me Too movement. And so, why should we aspire to justice under law, hopefully that's reformed to listen to the voices of women and of feminists, but still law? Why law? And I try in this book to tell the general public why law matters. And one chapter was called Law's Domain, but the publisher thought that was too abstruse, so I think I called it something like Prelude to Part 2. But in any case, it really is important to think at this moment, why is it better to aspire to capture the insights of women who have been abused sexually in codes of law against sexual assault, and then the civil law of sexual harassment? Why is it important to do things that way rather than to proceed by insults, by social media, and ruining people's reputation by public shaming? So yeah, I've learned to be a great fan of the law, and it's helped me in many, many ways. I used to be famous as the one who thought that decisions should be made highly contextually and very particularly. I was the great particularist. And although I still think there's some truth in what I used to say in my old writings on Aristotle, and I think it fits actually with the common law rather than the European systems of law, I now see much more in what's worthy of our dignity as persons in having a code of law that supposedly, anyway, applies to all in the same way. And, I've just come to value law a lot more, and it's changed the way I think as a philosopher. So in many other things different people would have to say. I'm sure each philosopher who goes to a law school learns different things, but that's what I've learned anyway. Okay, now, a while ago, Candace Mui had a hand up, but I guess she doesn't anymore. So Thomas Moore.
Yes. Hello. Thank you for the talk. I enjoyed it. It's pretty hard to disagree with your main point. I did hope that you would say something about the more recent curriculum changes at the law school. So I'm a 1L now, and I don't know exactly the details, but I guess now there's a con law is required. A con law course is required in the first year, whereas it wasn't before, and we have a transactional course. So I just wondered if you could talk a little bit about how these changes map on maybe both to Freund's ideas, because I think initially he had con law in the first, if I remember. But then also this the transactional course almost seems a little bit like a concession to the maybe 2L curriculum people with its more practical focus. So maybe you could talk about how this change maps on to these debates.
Okay. Yeah, I haven't been in on the conversations about this, and I don't know all the details, so I'm a little hesitant here. I don't know what arguments, for example, were used pro and con in these debates. But I do think the con law course and the inclusion of legislation, those are big Freund ideas. And, con law used to be required. I think when I arrived here in 1995, it was required. So it went out, and now it's come back in again. And so as for the transaction, and I think legislation is clearly a big Freund idea. The transactional class, as I understand it, as I've talked to Professor Weisbach and Professor Baird about what they're planning to do, it's not really the 2-year curriculum at all. It's going to be very ambitious. Its focus, its feet are in a concrete example, but then, as it were, it will ascend from that to general principles, and will certainly, with those two people teaching it, it will inevitably use quite a lot of economics. And in the case of both Baird and Weisbach, they're two of the people with the greatest interest in philosophy. I don't know how they're going to use it here, but I bet they will. Baird was actually an undergraduate classics major, and he was always very interested in philosophy, and in fact was the dean who hired me. He first had the idea that we ought to have a philosopher in the law school. And as I say, David Weisbach is somebody I teach with on a regular basis, and I know the depth of his interest in philosophy. So I think, although from the outside it could look the way you suggest, I think it's not going to be that at all. And I think it seems pretty exciting. Okay, I think we have time for one more. Is there? There has not yet been a question from a woman, and I always have this problem when people are asked to volunteer. And so I would really love to ask some woman out there to ask a question, because this is just not right that women just don't volunteer with questions. Okay, Kelsey Nelson.
Yes, so I wanted to ask, I guess, I really appreciated the talk, and I learned a lot, and I love the focus on the liberal arts education within law school and growing that as a science. I was wondering if you could touch more on the point of how this affects, I guess, the affordability of law school and the availability of it. I mean, and it's not particular to law school. It's definitely in all of higher education. Having it as a liberal arts education, making it not as available to people who maybe would want to partake and have to then it would be more available if it was more in the like a trade school.
Well, yeah, I mean, if you offer the liberal arts plus law school as an option, but also offer just straight into law school as an option, that's what Australia has been doing. I think that's really a bad idea, because it turns out, of course, that the government isn't going to make it cost free to do both. And then the people with means will do the combo, and the people without means will do the straight into law school. So one of the things we discussed in this conference a couple of years ago in Sydney was how they could not do that, how they could actually make the interdisciplinary curriculum available to everyone. So we're lucky that it's actually pretty much mandatory. You just can't get into a decent law school without a prior liberal arts education. So we first have to fight to keep it that way. South Korea, when they decided to go over to the US-based system, which was basically only in around, I think, 2014, so it's quite recent, it was the most prestigious law school, Seoul National University, that just says, no, that's what we're going to do. You have to come in with a liberal arts degree, and then it spread out from there. So making it kind of mandatory and de rigueur is crucial. But then it's also, it's on those undergraduate institutions not to burden people with the terrible, impossible debt. I don't see why law school should be penalized for the fact that undergraduate schools, especially, I must say, the public undergraduate schools, which have gotten so much more expensive in recent years, why law schools should pay for the fact that they're not making financial aid available enough. So issues about public education and its costs, loan forgiveness, debt forgiveness, all of those things, which, President Biden can't handle everything at once. Hillary Clinton made that issue central in her failed presidential campaign, but then, of course, it was failed. But it's one thing that we've got to handle. And so if students get to law school already encumbered, it's really going to be difficult for law schools to not burden them further. But I think we have to work hard, all of us, on fundraising for the University of Chicago Law School and other law schools like it. People like Rubenstein, who's been already into this, have to be alerted to the tremendous social importance of giving money to defray the costs of a law school education. The Rubensteins are 3 years cost-free, but of course we can't just have the Rubensteins, because that's for a small elite group, and I worry about the elitism of it, and that it creates a separate group. I think really everyone ought to have need-blind admissions to law school, but we're not there yet, so we have to work hard in our fundraising to get there. I think it should be a priority of the law school in fundraising, but in the meantime, just get scholarship aid in any way we can to particularly support the education of minority students, students from impoverished backgrounds, and so forth. And you know, everyone knows this, and everyone is working hard to do it, but it takes a while. But yeah, I think the issue of cost sprung out of nowhere, as it were, in 2010 or so, but it shouldn't have sprung out of nowhere. When I came into a law school, I was absolutely surprised because I hadn't thought about this before. I was surprised by the fact that these students were actually paying for a legal education. And later, when my own daughter went to law school, I was not surprised anymore, but I was paying for her legal education. So we got to stop that. And really, her education at the University of Washington was not all that expensive. But by now, all the public law schools have gotten more expensive, and everything is more than it should be. So I agree that that's a major, major issue. I think everyone knows that now, but they should have known it earlier, and we would be ahead of where we are now if people had known it earlier. Okay, I'm afraid I have to say goodbye to you all now for now, but please write me emails. I love email. I answer emails. And if you have other questions, write me emails. And take a class, please. Take feminist philosophy next year, where we also talk about trans issues and normative issues around gender transitions. So it's a fun course. Okay, goodbye. Have a great week.